This next series of Toolbox questions focuses primarily on arbitration and mediation again. This first question could go in several places in this course. How do you convince parties that they can be sincere and upfront in the mediation? The first point to make here is that consider this in the context of the traditional relationship where mediation is a separate and distinct process from arbitration. That should be a major selling point, that here you have a neutral, your client or you as the client can talk to, and everything is confidential unless you give up that right and you want it to be shared. And you also have some ability to craft how it is shared and when it is shared. If it's in the hybrid situation, it is certainly much harder to do. But the ultimate weapon there, and that's probably not the best word choice on my part, but that might be what it takes, is that you want to settle the case and not get to the next step. And that really works in both scenarios, whether it's traditional, separate mediation, separate arbitration, or a hybrid process. The job of who does the convincing is both that of the party's counsel as well as the mediator. Another thing that counsel can do is have their clients speak to other people who've been through mediation. If the client themselves have limited or no experience in mediation, it is good to speak to someone who's gone through it, particularly someone who is like-minded in how they conduct their business. In some of the discussions previously, you folks have shared certain personality types and people who have a distinct style of negotiation, and they may be the most resistant to being upfront in mediation. Most construction counsel are going to have similar clients and hopefully can get consent of one to share their experience. Not the details of the case, but that it can be an effective process. Ultimately, the issue is going to be giving up your control, giving up the issue to have somebody else decide it, either an arbitrator or a court, judge or jury, and that can be a very powerful tool of persuasion. There are no magic answers to this question other than getting the party to see that this is really the last off-ramp they have before they give up complete control to somebody else to determine the issue. Which brings us to, why do people use mediation over arbitration? For all the reasons just said in the previous answer, and as we've discussed in some of the other modules of this course. It gives the parties control. It at least prevents the significant relationship damage you can have from litigation and sometimes from arbitration. There have been some comments made that arbitration is a friendly process. It can be. It's not always. It is an adversarial process. It can be as aggressive and as unpleasant as people perceive litigation to be. Again, it doesn't have to be. Litigation's not always awful. And if you have a really strong legal case, this goes to the last question on this slide, that's when arbitration might be irrelevant. Where it's most important to go to litigation is if there is a need for precedent. If the dispute that is at issue arises out of a newly constructed law, it's important to have that law interpreted in a way that will be applied to clarifying the law for future cases. That helps with contract writing. The tricky issue is, though, most construction contracts have an arbitration clause. And absent party agreement, they can't go to court. When they realize the dispute that has come up revolves around that law and some ambiguity in it or perceived ambiguity, one party cannot unilaterally say there's a precedent issue here, we have to go to court. It would only be by agreement, and that's probably going to be unlikely. So the benefits of mediation, it's earlier on in the dispute, the parties have control. It can save relationships and hopefully future business contacts. Arbitration, benefit, you have an experienced construction person, whether it be a GC or a sub or a design person, or more likely the case, a construction attorney deciding the case. That person is not only familiar with the arbitration process, but familiar with the construction process. Usually a much better setting to be in than having a judge or jury decide the case. Timing, mediation's faster. Arbitration can be as slow as court, and both of them are aware of that. So both arbitration and litigation aren't as slow as they used to be, but a lot of that has to do with how the parties handle the process and what the docket is if you're in court. And that brings us to the next question about hearing days. Years ago, this was a huge, huge problem. Parties would set 1 or 2 days, and then it might be months before the next couple days were heard. Tremendously inefficient process. Arbitration got a huge knock for that, and parties were writing it out. But because the industry strongly prefers having cases that get this far decided by industry professionals or construction lawyers, great efforts were made to change scheduling. Training was improved, rules were improved, and that preliminary hearing process is critical. You're going to find that most arbitrators are going to drill down on this, and parties are going to be receptive to it. Counsel are going to do their best to try to clear their schedules and their clients' schedules so that you can do at least 3 or 4 days in a row. You might have a 2 or 3 week break in between. Arbitrators don't have the full authority that a court does to say that you will appear regardless of what else is on your plate. And sometimes what else is on a party or a lawyer's plate is another case in court, which they don't have any authority to change. Although sometimes judges are sympathetic. If a lawyer is scheduled for a procedural motion hearing in court, and that's the best day to get everyone in arbitration, that might be a reason to get a continuance in court, but probably not, because the court's docket is just as busy as an arbitrator's and counsel's are. But this is a very, very good question in that the delay between hearing days can be a huge time and cost escalator, and parties and arbitrators do work very hard to prevent it. Just talking anecdotally about past cases can be the motivator to say, yep, we're going to set aside 5 days. Another very, very effective practice that isn't as common as it should be is doing that end of every day check-in. Where are we? At the preliminary hearing, we expected to be through 2 witnesses by the end of this hearing day. We have just started with witness 2. What are we going to do to correct that? And why it is important to do this every day and not just do it at the end of the case is that perceived bias issue. If an arbitrator lets the first party, the claimant, go on with his or her case at his or her own pace, and then we're running out of time and people know their schedules are difficult, it's summer or it's the holidays or fill in the blank with what the issue is going to be, it's very difficult then for the arbitrator to kind of tighten the reins on the next party to go with his or her case. So that daily check-in is important. And it also helps people go back and regroup and say, how are we going to present our case? It gives the parties, and usually when I say parties here, I mean their counsel, an opportunity to ask some questions. Do we need to keep covering this issue? It can be a very delicate dance, but sometimes it's a private caucus with both sides or all the parties, attorneys, and the arbitrator at the end of every hearing day saying, where are we? What do we do to get back on track? Or congratulating the parties that they are on track and encouraging them to keep going and seeing if there are any other efficiencies they can make in the process. So this is an important thing to keep in mind. It's dangerous to put time limits in clauses because, as we've said in other discussions, we don't know what that dispute's going to look like when it actually arises. But setting time limits and having a good, thoughtful conversation at the preliminary hearing stage and sticking to the schedule is critical for arbitration to be perceived as successful. Go back to that first question in this section. Successfully resolved. If it was efficient, that's a positive. Which side should have more authority in structuring the arbitration process? This kind of flows from the last one, and there are several other issues that can come up in terms of structuring the process. The parties should definitely have input. It is their process. They have voluntarily agreed to do this and waive their right to go to court and have this resolved in a more flexible process. The problem is that flexibility can be a double-edged sword. And as we just saw with the hearing example, parties could agree, hey, we're going to do this in 20 days because that's what we want. They may not need 20 days, but if you give them 20 days, they'll take 20, if not 25. So my experience says the best process is to not overly tighten the arbitration clause, to generally stick with whatever rules, which usually allow some degree of party input, but ultimately have that arbitrator or panel be the decision maker if there can't be an agreement, or as the rules have changed over the years, let the arbitrator come in and say, this is not efficient, I'm going to make the following tweaks so it is more efficient. Some arbitrators have a backstop process saying we can revisit this at certain points to see how we're doing, leaving the door open. And this is what some arbitrators do to get over that perceived fear that I might get overturned. Remember, one of the statutory reasons for vacating an award is an arbitrator failing to let in material evidence, which is why 20 years ago they just used to let everyone put everything in, no matter how long it took, if the hearing days stretched over a couple of years. So now the better process is to have a really thorough, hard question asking preliminary hearing process, daily check-in, but ultimately the arbitrator has the authority to cut off redundant testimony, but also to allow a little flexibility to let someone go longer, so that there is no chance that the case is going to be challenged and try to have the parties try to vacate it later. But I'm sure there are lots of different opinions. I'm not sure. I know there are lots of different opinions on this question. It's really going to come down to the parties' experience. And again, what they know about the other side. But ultimately, let that arbitrator have some authority to modify things. And the next questions are going to take us a little bit into DRBs, so we're going to hold off on those for a minute.